This is John Watts. I'm an Alabama consumer protection attorney, and we're going to answer a question related to mortgages. So the question is, please explain what a notice of error is under the RESPA law for mortgages. So we have this law called RESPA that applies to mortgages. And there's a whole bunch of things that it covers, but for our purposes, we're going to speak about what does it say on something called a notice of error. So what is a notice of error? That's when your mortgage company has committed an error in what is known as the servicing. So that could be what they claim you owe, about, say, homeowners insurance being canceled, about credit reporting, about loss mitigation, loan modifications, basically anything that you're dealing with your mortgage company on. If they have made an error, you can give them this notice of error, and that gives them a chance to fix their mistake, to fix the problem. So what are some rules about that? Our suggestion is you do one error per letter. So if your mortgage company has committed 10 errors, we'll send them 10 different letters so that each letter is sort of self-contained and they can just look at that and say, okay, this is the mistake, this is the error we made. Now, are we willing to fix this error? Then they can go to the second letter and then the third letter. So you could have a mortgage company that has denied receiving a payment, but you have the proof that they received it and they cashed the check actually. And then the next month they say, well, since you're late, we're hitting you with a late fee. Well, that would be a second error. And then they report on your credit report. You could dispute that through this vehicle of a notice of error. And then maybe they say, and now we're going to start foreclosure proceedings. So all these different errors, they may be all separate or they may be interrelated. Kind of the first domino falls and that hits the next one, next one, next one. Either way, I would separate out the errors, so one error per letter. Now you need to send it to the correct address. You'll find that on the mortgage statement or the website. Now if they don't give you a special address to send, and usually they'll say a qualified written request, which is kind of the old-fashioned version of a notice of error, and then it'll say notice of error or request for information. We'll cover request for information in our next video. But it'll give you that address, or you go to their website, or you call them and ask them, what is their address? If they don't have a special address for this, then you can send it to just the normal address, but most mortgage companies have a specified address. You got to send it certified so you can prove delivery. Now you could do it overnight, you could do it, all different ways, but the bottom line is you have to be able to prove that your letter not only was mailed, but that it was received. Because it could be mailed and just not make it to the mortgage company. So you have to be able to prove it. And you have to understand that a lot of these mortgage companies have the mindset of, if we get it and it's not certified and the consumer, the homeowner cannot prove we got it, just throw it in the garbage. And then they say, well, prove we got it. Well, you can't. So you need to do it certified, overnight, however you want to do it so you can prove delivery. What we recommend is doing it certified mail. It costs you about $7 per letter. And that way they have to sign the green card and you know that they received that letter. Well, what happens when they get the letter? They have to acknowledge receipt in writing within 5 business days. So in other words, they get the letter, 5 business days goes by, they have to mail you an acknowledgement of the receipt of that letter. Now they can send you one letter that says, hey, we got 10 notices of error. We're acknowledging receipt. That's fine. Well, then they have 30 business days from receipt of the letter to correct the error. Or to say, hey, look, we examined this, we took a look at it, there's nothing we did wrong, we're not changing a thing. You have to do one of those. Either fix it or tell you they're not going to fix it. Well, what happens if they violate this law? Maybe they don't investigate or they do such a lousy investigation when it's obvious that they should have fixed the error, well, then you can get actual damages. So we also call these compensatory damages. They're to compensate you. So it could be that because of this error, you've been hit with a bunch of late fees, or maybe they've started a foreclosure, maybe they've taken your house wrongfully. So you could have a massive amount of economic damages. You can also get mental anguish. Obviously, the stress of somebody taking your house or threatening to take your house is incredible. You can also get statutory damages, and this can be up to $2,000 per violation. So if they take our example of 10 errors, you send them those 10 letters, they refuse to acknowledge them, they refuse to fix the problem, well, that may be 10 to 20 violations. So that could be $20,000 to $40,000 just in statutory damages. And then we can talk about what are the actual damages. So very, very powerful law here. They can also be required, the mortgage company can, to pay your attorney's fees. So they can pay their lawyer when you sue the mortgage company if you're successful. And they may be required to pay your lawyer. So here's the significance of this. When these mortgage companies get caught and they say, we broke the law, we did all this terrible stuff, but the homeowner caught us. They sent these RESPA letters, these notice of error letters, maybe also requests for information. We'll talk about in the next video. We got caught. We've been sued. What's our exposure? Well, here's the statutory. Have a lot of exposure, actual damages. And by the way, we have to pay the consumer's lawyer. They're like, oh my goodness, let's get this thing settled. Now, not always, but a lot of times, at least the smart companies, when they realize, okay, we did some bad stuff and we got caught, let's get this settled in a fair way so that we don't have to pay our lawyers a bunch of fees and the consumer's lawyers a bunch of fees. So very powerful motivator for them. Remember this, there are other laws that can apply. And we'll talk about this request for information. Usually if we're doing a notice of error, we're also doing a request for information, which is saying, give us some information. You may have the FDCPA, Fair Debt Collection Practices Act. We did a recent video on that. That's a very powerful law. There's false credit reporting. It may be the FCRA, Fair Credit Reporting Act. So there's any number of laws that may apply. We don't want to just be fixated on RESPA, but RESPA is a very powerful law and was recently changed to make it a lot more powerful than it used to be. So keep that in mind. Now, if you have questions that concern directly you, maybe a potential case you have, don't put those in the YouTube comments, but you can contact us directly. Again, my name is John Watts, 205-879-2447, or you can go to alabamaconsumer.com, contact us there. But if you have just general thoughts, comments, experiences, even criticism of this video, you're welcome to put those below in the comment. You're also welcome to like the video, to share the video, Twitter, Facebook, however you want to share it. If there's anything we can do to help us, feel free to give us a call. Again, it's 205-879-2447. We represent people all over the state of Alabama. And if you have other questions you would like us to cover, this is where we get the ideas for these videos, is your questions. You can either reach out to us privately or you can put it in the comments, and we'll be happy to add that to our list. And we'll keep going through these questions, and hopefully you have found this useful. Thanks for watching the video, and I will talk with you soon. Thanks. Bye-bye.